Madam Speaker, I'm pleased to participate in the third reading debate of Bill C-5, an act to amend the Criminal Code and the Controlled Drugs and Substances Act. Let me begin by acknowledging that I'm speaking to you from the traditional unceded lands of the Algonquin peoples. At the outset, I'd like to thank my colleagues of the Justice Committee for their diligent work in improving this bill and moving it forward, and many witnesses who came forward to speak about their lived experiences. Bill C-5 addresses systemic racism and discrimination in the criminal justice system by promoting a fairer and more effective justice system that, among other things, will provide courts with increased judicial discretion at sentencing through the elimination of some mandatory minimum penalties of imprisonments and restrictions on the imposition of conditional sentences of imprisonment. Further, the bill promotes alternatives to charging and prosecuting individuals in cases involving simple possession of drugs. We see again here the opposition attempting to reinstate mandatory minimum penalties in the legislation, MMPs which we have clearly seen that do not work. I'm proud of the announcement our government made Monday to crack down on illegal and dangerous firearms in Canada, including raising maximum penalties for many firearm offenses. Together with this bill, we are restoring discretion to judges, ensuring that fair sentences can be applied and the serious crimes will still receive serious sentences. The Comité de la Justice.
The Justice Committee has now concluded its study of the bill and reported back to the House of Commons with 4 amendments that, in my opinion, reinforce the bill.
C-5's amendments provide space to treat the simple possession of drugs as a health issue rather than a criminal one, as it should be, and is consistent with the announcement made by the Minister of Mental Health and Addictions yesterday for British Columbia. The bill requires police and prosecutors to consider alternative measures, including diverting individuals to treatment programs, giving a warning or taking no further action, instead of laying charges or prosecuting individuals for simple possession of an illegal drug. Further, it would provide a declaration of principles to guide police and Crown prosecutors in the exercise of their discretion. Among other principles, the bill would recognize that scarce judicial resources should be reserved for offenses that pose a risk to public safety, and the criminal sanctions imposed in respect of the possession of drugs for personal use are not consistent with established public health evidence. The principle enacted under Bill C-5 do not condone the sale of drugs as it may result in the death of purchasers, including purchasers who may be youths or first-time users who are at greater health risk from consuming high concentrated drugs. Condoning the sale of drugs would be contrary to the government's ongoing efforts to combat the opioid crisis and deaths. Further, such an approach would also be contrary to the harm reduction and prevention pillar of the Canadian Drugs and Substances Act. Mr. Speaker, let me be clear. Bill C-5 is only one part of a larger government strategy to fight the ongoing opioid crisis. On May 31st, 2022, the Minister of Health, Mental Health and Addictions and Associate Minister of Health announced that the granting of time-limited exemption under subsection 56(1) of the CDSA to exempt the application of simple possession offense to the personal possession of small amounts of controlled substances commonly involved in overdoses deaths by adults 18 years or older in the province of British Columbia. The exemption is part of the province's comprehensive approach to address the overdose crisis and intended to reduce harm for people who use drugs and promote better access to life-saving health services in the territory. Before I go into the other parts of the amendment, Mr. Speaker, I do want to highlight the report by the Auditor General of Canada to Parliament yesterday. And when I speak about the need to avoid prison sentences for those who are virtually no risk, who pose no threat to the public, particularly from racialized communities, particularly from Indigenous and Black communities, it is because we know that systemic racism is prevalent within many parts of the criminal justice system. The report by the Auditor General yesterday makes it crystal clear that there is a disparity in the manner in which we treat Indigenous and Black offenders. For example, Mr. Speaker, and I like to read parts of the report, it says, Indigenous and Black offenders face greater barriers to a safe and gradual reintegration into society than other incarcerated groups. She goes on to say Indigenous and Black offenders remained in custody longer and are at a higher risk level of security before their release. So essentially, our correctional services mischaracterizes or categorizes offenders based on low, medium, high risk, and it is clear that there's a disparity in the manner in which they classify Indigenous and Black offenders. For example, we found that Indigenous and Black offenders were placed at higher security levels on admission to custody at twice the average rate of other offenders. She goes on to say, we found that although the majority of offenders were released on parole before the end of their sentences, fewer Indigenous offenders were released when first eligible. In fact, more Indigenous offenders remained in custody until their statutory release and were released directly into the community from a higher levels of security, and they did not obtain the right level of support for them to go into the community and integrate. Indigenous offenders served longer portions of their sentences in custody than the average, placing them in a disadvantaged access to early release or paroles. And it's a report that's so important, I believe, to this discussion today, Mr. Speaker, because when we speak about ensuring that we minimize those going into the criminal justice system, it does not say that we treat everyone the same. What we're saying is that if you pose no risk, if you are a low-risk offender that does not belong in jail, then you have other alternatives, and as a government, C-5 really addresses some of the root causes of both the mandatory minimum penalties as well as avoiding jail sentences, which we know from the Auditor General's report does have adverse impacts on Indigenous and Black Canadians, particularly Indigenous women and young Black men. So let me talk about the amendments at this stage, Mr. Speaker. The first amendment would clarify the kind of information kept in the police record of warning and referrals, the use that can be made for such records, and to whom they may be disclosed. For instance, as amended, any information contained in the record of warning or referral may be made available to a judge or a court for any purpose relating to offense proceedings or for the preparation of a pre-sentence report, but limited to circumstances to which the record relates. These changes address the concerns raised by several witnesses that such records could be improperly applied and frustrate the objectives of this bill to promote diversion, while recognizing that police officers are legally and ethically bound to keep notes to facilitate various operational requirements of the criminal justice system. To address these concerns, the second amendment here provides a mechanism to reduce the stigma associated with convictions for simple possession of drugs by specifying that past and future convictions must be kept separate and apart from other criminal convictions after a certain period of time. These new measures would need to be implemented by 2 years after the coming into force of the bill in the case of convictions that occurred before the bill comes into force, and 2 years after the conviction or completion of the offender's sentence in the case of convictions after Bill C-5 is in force. The third amendment, Mr. Speaker, would provide an express provision to clarify that no social worker, medical professional, or service provider commits the offense of simple possession where they come into possession of a controlled substance in the course of their duties and they intend within a reasonable period to lawfully dispose of it. While we believe that this particular amendment is covered in the innocent possession common law defense, we were able to work with the opposition in order to strengthen the bill to have a bit more clarity, and it's incorporated herein. The last amendment to Bill C-5 requires a comprehensive review of the provisions and operations of the bill to be undertaken by the House on the 4th anniversary of this bill coming into force, Mr. Speaker. In conclusion, this is a very important step forward to address common sense criminal law reform. It is embedded, it's under the basis that this mandatory minimum penalties in many cases have not had a positive impact on communities, particularly Indigenous and Black and other racialized communities, and it is a very important step forward in addressing the systemic racism that we have within the criminal justice system. Thank you, Mr. Speaker.